Jamal Akeem Walton.
All right, thank you. You may proceed.
Mr. Walton, do you have any other children that you provide support for?
Yes, sir.
How old are those children?
15 and 11.
And that would be two children, correct?
Yes.
Okay. Where are you currently employed?
I am employed at Manpower Temp Services.
Okay. And how much do you make?
I told you earlier when we discussed it, I don't have no clue right now because I just started.
When you were previously employed, what did you make per hour?
I believe it was the last temp job I had was about 19.
So you're capable of making about $19 an hour?
No, not in the state of Texas.
Why not?
Because most jobs around here does not offer $19 an hour.
All right, sir, where do you live?
Clean.
All right, how long have you lived in Killeen?
About 5 years now.
All right, where have you lived other than Killeen, Texas? You lived anywhere else other than Killeen, Texas in the last 5 years, sir?
Nope.
All right, and when's the last time you had a full-time job?
2019.
All right, and what have you been doing to make a living since 2019, sir?
Temp jobs. That's it.
All right, and you said you just testified the last temp job you had, you said you got paid $19 an hour?
Yes, sir.
And where was that job located?
Sojo Industries at Temple.
All right, so you did earn that in Bell County, Texas. Is that correct, sir?
Yes, sir.
And how long did you work there?
About on and off about 6 months.
All right, thank you. You may proceed with the witness, Mr. Green. Thank you.
What are you asking the court to do here today?
I'm asking for a extension so I can better get an understanding of what is being processed here, because I signed papers saying that we was doing paternity and paternity only. I didn't sign no paper. I didn't receive no other
Objection,
papers.
non-responsive.
Okay, sir, I'll be back in, but sir, okay. The objection is granted. We'll go into that in just a moment, sir. I'll let the state proceed with questioning. Thank you. You may re-question the witness.
Why are you requesting a reset today?
I am requesting a reset to seek legal counsel to better get an understanding of what is happening today, because I have requested and demanded that I receive copies of
Objection,
paperwork, but I have
non-responsive.
not.
Okay, here's the deal, sir.
Now I'm responding back.
Okay, here's the deal, sir. You listen to the question and answer the question. I showed no pleadings on your behalf in the court file with any type of request for production or anything else, sir. I'm not sure what you're talking about.
I went down to the child support. I am the one that went down to the child support people here in Bell County, here in Temple, Texas, and had to look up this file. When I looked up this file, I asked them for copies of the paperwork dealing with this case so I could take it to legal counsel. I have not received that legal counsel yet.
All right, here's the deal, sir. Let me look at the file again. Here we go.
I went to Bell County.
All right, then, sir. I'm not going to. Okay. And the paperwork shows that you were served with a copy of the paperwork at 301 Priest Drive, the constable's office in Killeen, Texas, on the 8th day of April, 2025 at 9:30 a.m. That affidavit is sworn to by the constable that served you with that paperwork, sir, and that included all paperwork, including the request for child support and the UFSA packet.
No, sir. I got a paper. I got one paper saying that I was getting put on child support, and one paper saying who I need to contact. I went down to the office prior to that. At the beginning of the year, I went down to the office. In the beginning of 2025, I went down to that office myself.
All right. Okay.
Because
and sir, okay. And the second thing,
I had
sir,
the
is
paper.
that on the 25th day of July, you signed off on an order for paternity testing that was submitted to this court, that was signed off on by the Attorney General's office and yourself, and then by me.
Yeah, I signed off on paternity.
You signed off on for a paternity test, sir. So you've made a legal. At that point, you had been previously served, and that affidavit is on file. And you also signed off on an order for paternity testing. So you were properly before the court on all matters concerning this case, at least until July, when you signed off on the order for paternity testing. Correct?
Your Honor, I went down there myself to receive the paperwork. When I went to the constable office,
sir, that's not my question. My question was, you admit you signed off on that order for paternity testing, correct? And that was in July of this year. Am I correct or am I wrong? Last year, sir. Am I correct or am I wrong?
you're right, Your Honor.
Okay, you signed off, so you knew about all this, and you were before this court at least since July of last year, sir. That's the legal definition. I know you're not a lawyer, but that's the legal circumstance. So what? Okay, and so you've known since then, and you've had since then to seek legal counsel. So is there a reason why the court should not at least do a temporary order in this case based on those circumstances?
Your Honor, as I am saying, when I wanted to receive the paperwork, I did not receive paperwork. Therefore, due process was not. I had to go find you.
Okay, here's
on
this
this matter.
If you're alleging you did not receive the paperwork, I got an affidavit that says.
When I went to the consular office, they gave me 2 sheets of paper.
Okay.
One saying that I need to get in contact with the child support office in Bell County, which is how I already knew your address, but I took that paperwork down there and requested paperwork. I have not received the paperwork yet.
You took
pertaining
the paperwork
to
where,
this
sir? You took that paperwork where?
To the child support office, right here off behind Texas Roadhouse here in Temple.
Okay.
What is that, airport, I believe?
Yes, sir.
Yes, I took the paperwork down there.
That's why it's 1 block off the airport. Yes, sir.
Took the paperwork down there to get the copies so I can take them to a lawyer. So I can have a lawyer look over this case. And we could establish something.
All right, sir, you signed off on the agreed to order to do DNA testing. That's back. Your dad. So why should I not go ahead and do a temporary order granting child support based on these circumstances?
Other than that, I take care of my kids.
That's a lie, Your Honor.
All right, stop. Do not, ma'am, you're not the witness. And here's the deal.
I have been alienated from that child for how long?
Okay, here's the deal, sir. Here's the deal. Stop. I'm going to go ahead and do a temporary order today. This is your child. This child deserves child support, and I'm going to order child support going forward.
I'll take care of my child. That's what I'm trying to tell y'all.
Here's the deal, sir. Going forward, you're going to take care of the child through the state's disbursement unit like everybody else who's been declared.
I object, and I do not give y'all jurisdiction in no way, shape, or form in this matter.
Sir, you waived the fact to object to jurisdiction.
I did not know because I did not waive no factor based off of
Mr. Walton. I'm not going to argue the law with you. You're not a lawyer, and I'm not going to argue the law with you.
I'm not a lawyer. You're not a lawyer, but I know my rights.
No, you don't, sir.
I have to learn my rights.
Mr. Walton, you're getting ready to have to go through the contempt.
At the end of the day,
Mr. Walton, stop before I hold you in contempt and order you into jail. Stop.
That's what y'all want to do. That's what y'all want to do. All right.
No, sir. I'm not going to argue with you about this, sir. I'm going to go ahead and set up a temporary order ordering child support going forward. You go talk to a lawyer, and your lawyer will tell you everything I just told you.
Why are y'all muting me?
Because Because, sir, they're trying to keep you from being put in jail. That's what that's what they're trying to do. So at this point, I'm not going to argue with you anymore, sir. I'm going to go ahead and set up a temporary order, and I'm going to set up temporary child support. And I'm going to give you 60 days to go out and find a lawyer and let your lawyer and you come back in and argue anything that you wish that is legally before the court.
Nah, see, I would like to challenge this case in the whole
Sir,
case.
sir.
Under my 14th Amendment rights, I would like to challenge this case for fraud, invalid information, and due process.
Well, sir, the court will duly note everything you just said, but right at this point, Mr. Walton, you have not filed anything specifically with the court. I'm going to go ahead and do what I'm allowed to do, sir. And you can go ahead and take all that to your new lawyer.
Where's your courthouse?
Lawyer do it properly.
Where's your courthouse? You're at Bell County Court.
Here's the deal, Mr. Walton. Mr. Walton?
Are you at Bell County Court? That's what I'm asking.
Mr. Walton, I'm not going to tell you where I'm located. And you're getting ready to go to jail, Mr. Walton. You show up down here, you'll be able to warrant for your arrest.
I'm coming down there to file paperwork today, right now.
All right, I'm in the car right now. In contempt of court. I'm sentencing you to 30 days in Bell County Jail. I'm going to have
contempt of court for what?
You show up and you will be placed in jail by any constable or deputy. You understand me, sir? That's it.
30 days in court for what?
30 days in Bell County Jail, sir. Right now, starting immediately.
All right, guys, buckle up. Because right from the opening seconds, the judge begins pressing Jamal Walton about his finances and work history, setting the tone for what's clearly going to be a serious child support case. Walton admits he works temp jobs and previously earned around $19 an hour, but quickly tries to downplay his earning ability in Texas. The judge doesn't let that slide, carefully walking him through where he lives and where he worked before. You can already feel the court building a picture of someone capable of earning more than he claims. This part quietly establishes responsibility, credibility, and the financial expectations that will drive the rest of the hearing. It's calm on the surface, but the tension is already brewing underneath.
For what?
For contempt of court, sir.
This is not contempt of court, Your Honor. I'm pleading my case.
Mr. Walton, I just found you in contempt. That's it. 30 days Bell County Jail. Mr. Gwynn, go ahead and prepare the temporary order. I'm through arguing with Mr. Walton. Go ahead and prepare the temporary order. Go ahead and compare the warrant for his arrest and being in contempt for 30 days. And I'll give it to all the necessary constables and deputies for that issue. And I will go ahead and I'm through arguing with Mr. Walton. I'm making this a final order, Mr. Gwynn. I'm not making this attempt. This is the final order.
Mr. Judge.
All right, Mr. Walton, sir, I'm going to, instead of making this attempt, I'm making this a final order. I'm also holding you in contempt. I'm sentencing you to 30 days in Bell County Jail for contempt of court. And I'm going to have a warrant issue for your arrest on that, sir. And if you, I'm going to go ahead and I'm going to go ahead and grant
I'm coming to the courthouse now to file this paperwork.
Sir, you can come to the clerk's office and file whatever paperwork you think is necessary, sir, or hire a lawyer to do it for you.
All right, guys, this is where things start getting heated as Walton asks for a reset, saying he doesn't understand what's happening and wants a lawyer. He insists he was never properly served with paperwork and claims due process was violated. The judge responds firmly, pulling up court records that show Walton was served and even signed off on a paternity testing order months earlier. As Walton keeps explaining trips to the child support office, the judge cuts through the confusion with legal facts. You can feel Walton trying to shift responsibility while the court methodically shuts down each excuse. This back and forth is critical because it shows the court establishing authority and proof, while Walton grows increasingly defensive.
I'm coming down here to file a paper. That's all I was asking. What courthouse are you in so I can come down here and file this paperwork and get this put in the court? You up there talking about contempt.
Sir, I cannot tell you how to practice law. You can practice law at however you want to, but a lawyer would know that you have to file your paperwork at the district clerk's office of Bell County, Texas. That's it. If you have legal paperwork, sir.
That's all I was asking.
All right, here's what I'm going to do, sir. I'm going to rescind my contempt. All right. You can file whatever necessary paperwork you think is necessary, and you can file it with the district clerk's office. But you're now you have to file everything in conformity with the Texas Rules of Civil Procedure, with all proper notices to any and all participants in this case. I'm going to go ahead and set up a temporary child support amount based on what the state's requested. The child support, the cash medical are going to start
What
on
has
the
the state
first day
requested? I haven't even heard what the state requested.
all child support will start the first day of February 2025 and 2026. And I'm going to go ahead and reset this matter. Let's see, this is the 29th of January.
Yep.
All right, I'm resetting this matter for final hearing on the 26th day of March on the general Zoom docket at 9 a.m. By then, sir, you will get all information concerning the reset date, and you can show that to your lawyer if you have a lawyer. And the court will have the court file at that time, and anything that you have filed, the court will have in its possession. However, sir, you do have to conform with the Texas Rules of Civil Procedure as far as notice and all requests as far as other parties in this matter, which means the state of Texas and Ms. Daniels, and you have to do so in conformity with those rules, sir. So if you don't have a lawyer, it's up to you. If you do have a lawyer, your lawyer know how to take care of that. So at this point, Mr. Walton, you have any other questions, sir?
Excuse me, Your Honor.
Yeah.
March 26th, that's the Coriel in-person docket.
Okay, y'all move that. All right, I'll go ahead and move it to the, let me bring it back up Zoom.
Well, I can do it in person right here in Texas.
All right, guys. Now the real confrontation begins when the judge decides to move forward with a temporary child support order. Walton immediately objects, claiming the court has no jurisdiction and insisting he knows his rights. The judge warns him to stop interrupting and makes it clear that the child deserves support regardless of his objections. Voices overlap, frustration rises, and the courtroom energy shifts from procedural to explosive. Walton keeps pushing back, while the judge stays firm, explaining the law isn't up for debate. This moment feels like a tipping point, where Walton's resistance only makes things worse. It's the emotional peak where authority meets outright defiance.
Okay. All right, let's go back a week.
Right here in Texas. He's going to fuck that.
Okay, this week is spring break.
Trying to keep me.
All right, Belinda, I'm not sure. The general docket for the 2nd of April, is that, I'm not showing anything there. I see my Zoom codes down there, but I need to confirm that's a correct date. Ms. Walker, is the 2nd of April is showing up as a general docket date, Thursday the 2nd?
Let's see, because if the second might be a special setting, Your Honor, since we're doing the first for the enforcement.
Right. Okay. All right. Yeah. All right. I do know that the 10th is definitely a general docket date. So I'm going to go ahead and reset this matter for final hearing on that date. We'll go ahead and use that's March the 10th. Let me get to second week of April.
Alright, guys, this final stretch takes everything to another level as the judge holds Walton in contempt and even orders jail time before later adjusting the ruling. The court makes the child support order final, lays out the exact payment amounts, and sets new hearing dates. Walton continues questioning the process and refuses to sign anything, but the judge calmly explains that the case will proceed with or without his signature. There's a clear shift from argument to firm legal closure. The judge lays down consequences, timelines, and expectations, leaving no room for confusion. It ends with the court fully in control, while Walton's protests fade into the background.
I don't have it as a special setting, but I don't know if you want to make that a general docket, because on that Tuesday, which is March 31st, is the Lamb Passes in person. And then the Wednesday is the bail in person. So I don't know if that Thursday is going to be a general or a special.
All right, let's go ahead and just use April the 14th. That's a general docket date, and that's when we reset to. They'll give him a total of 8 weeks, 10 weeks to get his ducks in a row and hire counsel. All right, so this time, sir and ma'am, I'm resetting this matter to that day in April at 9 a.m., and that's also a Zoom docket. Again, sir, you have until that time frame to retain counsel, to file necessary paperwork yourself. Your lawyer know how to do it, but sir, the warning is you have to file everything in conformity with the Texas Rules of Civil Procedure. Otherwise, you may not be able to argue any points you make if you do not do this correctly, like a lawyer would. So at this point, Ms. Daniels, again, I'm looking at doing child support starting the first day of February, and so that's due the first day of February, again on the first day of March, and again on the first day of April. And I'm looking at doing a final hearing on this matter on the 14th day of April. And again, that's going to be on Zoom, so you're allowed to appear, ma'am, on Zoom, or you would be allowed to appear no matter what electronically, based on the fact that this is a UFSA case. So, Ms. Daniels, do you have any question or anything else you're asking for? And then I'm going to go back to Mr. Walton.
So today we're just doing the temporary order?
Yes, ma'am.
Okay. No, that's fine.
All right. Thank you very much. All right, Mr. Walton. Question, sir.
No, Your Honor, I'm as soon as we get off, I'm coming up to Bell County anyway.
All right, Mr. Walton, again, the clerk's office only takes pleadings. If you're showing up to do something, you need to have something in writing to file with them that's appropriate, sir. So just showing up will not get you anything.
I'm just coming to get my paperwork so I can put my paperwork in.
All right, thank you very much, sir. Anyway, sir, the reset date is that date. The child support starts the first day of February. And to confirm the child support amounts and the cash medical amounts the state's requesting again, Mr. Gwynn, what are they, please?
Thank you. I was going to remind the court. I feel like it got washed out in the mix, but the guideline medical based on $19 an hour will be $49 with a guideline child support of $445.
49 cash medical.
I mean, how are y'all getting these numbers? Y'all are just
child support amount again, sir?
$445.
$445.
All right, and those amounts are ordered by the court.
And just to make sure I heard correctly, the reset date is the 14th of April at 9 a.m.?
Yes, sir, that is correct. And again, that's on Zoom. Yes, sir.
Violate the shit out of my rights for this sentence. I know.
All right, is there anything else at this time, Mr. Gwynn?
There's not, Judge.
May the parties be excused?
If they can be placed in the breakout rooms, I'll have that order before them fairly shortly.
All right, then. I'm assuming Mr. Walton is not going to sign, but again, I'll let you put them in breakout rooms, and again, the court will note that for the record and sign off once presented. Thank you.
I will not sign nothing.
Now, again, sir, the court will proceed without your signature. Thank you both very much, and we're off the record, and we'll see you on April for final. Thank you.